You may be seated. Good afternoon, everyone, and welcome to Division 6 of the Colorado Court of Appeals. Before we get started, I'd like to introduce you to Division 6. Sitting to my right is the Honorable David Furman, and sitting to my left is the Honorable Stephanie Dunn. My name is Rebecca Freyre. We have 3 cases on this afternoon's docket, and I see that counsel are present on the first case, Lands West v. Ferris. Do we have counsel present on the next case, the Hodge case? Thank you. Before we get started, both counsel should have received the policy and procedure sheet for the Court of Appeals, and I want to ask at this time whether either of you has any questions about any of those things. Thank you. All right. Just a few reminders. Please enter your appearance with your full name and registration number. Your time will not start running until after you have done that. Each side has 15 minutes for argument, and it will be up to you to keep track of your time. And the appellant, you can split your time however you want. There is a toggle switch on the bottom right portion of the podium, so feel free to adjust the podium to your needs when you get up there. Finally, these proceedings are being live streamed. For that reason, please be mindful of any information that you would like to keep confidential, and don't say it, because once you do, it's no longer confidential. Also, for that reason, if you have any electronic devices, please turn them off, because even receiving messages in, email messages or text messages can interfere with the live streaming equipment, is what I'm told. The oral arguments will be available for public viewing on our website probably later this afternoon, if not this afternoon, first thing tomorrow morning. So with that, we will call the first case, Lands West versus Ferris. Counsel, you may proceed when ready.
Good afternoon. My name is Charles H. Willman, Charles H. Willman, PC. My registration number is 6781. As you know from review of the matters I'm sure that you've done before the proceedings today, this is a case concerning the application of Rule 102 in the issuance of 4 writs of attachment by the district court. It is the appellant's position, and I'll call it petitioner just so I don't get mixed up on parties, but the petitioner's position that the first writ, as you know, was discharged by the court because the return of service was not done within the 21 days by the rule, and the second writ was done without a hearing. So it's our position, for that reason, the second writ should not have been granted. And then to summarize, there was the third and fourth writs, which were titled first renewed and second renewed writs, and it's our position that new affidavits, not an incorporating of affidavits, is required under the rule.
Mr. Willman, excuse me.
Sure.
Reviewing the record, I just want to make sure I understand which writs were traversed. So the first one was dissolved. Second one was traversed, but no hearing. The renewed and alias were traversed, but no hearing. I did not see a traverse of the last second renewed. Was that one traversed?
That is correct. I did not file a traverse of that one.
Traversed.
I was relying, frankly, on the law and what I'd cited in the traverse of the second amended complaint. First renewal, I'm sorry. So I did not file a traverse of the second one. That is correct.
The other 3 were, besides the first, the other 3 were traversed
Yes,
with
ma'am.
no hearing. Okay.
Yes, ma'am. So the issue in our view is that, as under the Jane v. Peck case, that the court must strictly construe Rule 102. And the reason for that, I think historically, when you review this, is prejudgment attachments are discouraged because essentially they're allowing the seizure of people's property without giving them a right to even defend as to whether there's a valid claim against them or not. So that public policy is very significant. And the district court in this case, why I believe, and she's a good judge, I practice in front of her often, made several mistakes in this case. When the second the second writ of attachment was issued based on after the first one was dismissed, it was based on the affidavits on both sides' part. From the previous time, the plaintiff in the underlying case did not, they attached a new affidavit, but essentially what they did is incorporate the affidavit by Ms. Rogers of the first one, and then added some of the evidence that had come in at the first hearing. The court, in the nature of judicial economy, found that there was a proper traverse, but did not hold a hearing because she felt it wasn't going to serve any useful purpose. It's our position that that would have served a useful purpose because there would have been a pass-through time, new evidence could be produced, and number one. Number two is there is a strict requirement that that hearing be held for each one where the court finds there's a valid traverse, which the court did.
Counsel, understanding that the rule does require a hearing, did you make any sort of offer of proof to the court about what additional evidence might have been adduced at a second hearing? You just mentioned the passage of time would have created additional evidence. Did you?
I did not, but there was never any opportunity to do so either because the court simply did not hold the hearing and then ruled relatively in quick order after that and denied that second traverse. So there was not, in my view, an opportunity to do that, but I did not do that.
Could the court have taken judicial notice of the contents of the first hearing in lieu of a new hearing?
It's my position that the rule doesn't allow for that. I understand the court could take judicial notice under the rules of evidence on a number of things, but not necessarily in this case does the rule allow the court to do that. We believe that was fault part of the trial court in not allowing that second hearing. And I do, again, believe it wasn't just a ministerial act. Again, without going back and trying to put myself 2 years back and what my mindset was at the time, there could have well been new evidence based on the testimony that happened at that first hearing, or new methods of examining that evidence on a part of us in cross-examination.
Mr. Woolman, I'm sorry to interrupt, but I had a question, a follow-up from Judge Dunn. The second renewed writ when there was no traverse, what's the effect of that on this appeal?
It's my position on the second renewed traverse, and I thought I argued that, but maybe I didn't argue effectively, is that the court was without jurisdiction. That gets into the amount of money that had already been seized, which I raised in part of the traverse of the first renewed, that the amount had exceeded the amount that was even under the best scenario, the 3 times 1.15 million, that had exceeded that value, and that was in the summary. And I don't know if you looked at the summary damages that I submitted with that the traverse of the first renewed writ, but it was my position at that point the court was exceeding its jurisdiction, therefore there wasn't a need to file a traverse. That's what I mentioned in response to the other justice, that I felt I had already addressed that issue the court didn't have the continued jurisdiction issue for the writs, which gets again to doesn't get again, but gets to the issue of the money. The judge in the writs, although in the whereas paragraph notes that the whereas, this was prepared by plaintiff's counsel, says, well, the plaintiff's damages are 1.15 million. It doesn't say in the writ itself in the direction to the sheriff how much money the sheriff is to seize. And if you looked at the exhibits, which are the emails between my office and the county attorney's office, it was real clear that the county attorney was saying, we got to seize everything. That's what we read the order to be. I tried to get the court to confer, to get a specific amount of money, and I thought it should be a lot less than the 1.15 million, but the court refused to do that. And I believe that also, the court exceeded its jurisdiction in issuing a writ without putting in any of the writs it issued an amount of money the sheriff was to seize. Because essentially what the district court did is allow the sheriff's office, at the request of the plaintiff, and the plaintiff was actively involved with the sheriff's office, in seizing any and all assets of my clients except for a few minor assets which the sheriff's office conceded were part of their exemption amounts.
But counsel, doesn't subsection F of Rule 102 allow the court to direct the sheriff to serve a writ for all the property, or
It's my position.
or as
I'm
much
sorry.
as to satisfy the plaintiff's claim? I mean, it seems like the or gives the court 2 options under the plain language of the rule, and that all property is certainly an option that the court has under the language of the rule if we're going to construe the rule strictly.
The subparagraph F of Rule 102 says that you must seize so much of the defendant's property as sufficient to satisfy plaintiff's claims, quote, the amount of which shall be stated in conformity with the affidavit, quote.
Right,
So
but
the
that comes after the or. What precedes the or is keep safely all the property of the defendant. So it seems to me it's an all the property or so much thereof as may be sufficient. And here the court chose all, and you were obviously asking for an amount sufficient to satisfy the plaintiff's claims.
If with all due deference, if your interpretation is correct, if you say all, let's say my client said $15 million, and everybody agrees his claim was maybe $3 or $4 million, could they seize 15 million? That's essentially what all that would mean. The court doesn't know when it's issuing the writ how much asset, what the level of the assets of a party that's going to have their assets attached, how much they have. That's why the rule has, you have to put an amount. In this case, we believe the amount that was proven, that was shown at that first traverse hearing, was somewhere at the most in 600,000, and maybe as little as 150, because Ms. Rogers testified the only thing she could give with any certainty was $150,000. That's why that is such a critical component here. Otherwise, any plaintiff can come in, and unless if there's a traverse and say, oh, we don't know exactly what our damages are, they're probably $30 million, and seize somebody's assets. They can't do that. The court has to make a finding as to what those damages are, and has to then say to the sheriff, you can only seize assets up to that amount. Otherwise, the wording, the rule that says you must specify amount doesn't make any sense. And when you tie that into the fact that defendants can post a bond and other things like that based on an amount, that they can't do it. You know, they can't post a bond because the sheriff's office doesn't even know how much bond to post on that, and they're the ones that are in charge of that. Unless they have clear direction from the court, they can't do that.
Mr. Willman, I want to return back to a question that Judge Furman was starting to, or asked. And that is there any practical effect if we were to dissolve the middle writs, the second, the renewed writ, if the one that you didn't challenge, the last one, they all say all personal and real property on the property list will remain attached by the Garfield County Sheriff's Office until further order of the court. That one is not traversed. The trial court didn't rule on it. So wouldn't all the property be subject to that unchallenged writ?
Again, if the amount already seized didn't exceed the amount that was reclaimed by the plaintiff. In the plaintiff's best case again, which is 1.15 million times 3 is around 3.4 million. And as I showed in the summary, they had already, in response to the first one, they had already exceeded that amount. So it's our belief that the issuance of that second, my position is the issuance of the second renewed writ exceeded the court's jurisdiction. And when the court's jurisdiction is seized, we can be challenged at any time, and we don't have to necessarily traverse that writ. So that was the logic in which that was approached. It was pretty clear at that point the district court was not going to allow further traverses. And I know that doesn't mean I shouldn't do it, but that was my position that I put into the traverse of the First Amendment, a renewed writ, and therefore I felt that position carried through because we felt the court had already exceeded its jurisdiction by not setting the amount and by the fact that the amount seized was there. I would like to reserve pretty much my last 5 minutes unless you have other questions. Oh, I guess I want to say one more thing. I don't want to lose track of that attorney's fees on the first. It's our view that we should get our attorney's fees when the court declined quash the first writ, for lack of a better term. We believe the rule is mandatory. The court had to do that, and simply because they won on the second is not a great reason not to reward those attorney's fees. And with that, unless you have a question on that issue, I reserve my remaining time, which is a little under 4.5 minutes at this point.
You can
Thank you
reserve.
all.
Thank you.
Good afternoon, Your Honors. Lucas Van Arsdale, registration number 42574 for the appellee, Lands West Ventures, Inc., DBA Bear Wallow Ranch. 3 main points that I'd like to make today. First, the trial court acted within the boundaries of Rule 102 in issuing the second and subsequent writs of attachment. Second, no provision of Rule 102 contemplates the trial court making findings of fact regarding the value of the plaintiff's claim. And third, the sheriff's failure to file an inventory within the 21 days required under the rule does not give rise to any right for the defendant to recover its attorney's fees from the plaintiff. Turning to my first point, the trial court acted within the boundaries of Rule 102 in issuing and upholding the second and subsequent writs of attachment. At the time the second writ of attachment was requested and issued, the trial court had already conducted a full 2-day evidentiary hearing on the defendant's traverse of the first writ of attachment. The evidence admitted at that hearing was the exclusive basis for the plaintiff's request for the second writ of attachment. No evidence outside of what was admitted at the hearing was introduced in the plaintiff's affidavit. The second motion to traverse, although called a traverse, did not meet the requirements of subsection 102N1 for traverse. It did not attach any affidavits that placed any facts that placed any of the bases for attachment at issue.
Mr. Van Arsdale, sorry to interrupt. What do we do with the Jane opinion?
Jane is inapplicable here. The applicable opinion to this specific issue is Old Republic v. Cornegay. In Old Republic, the defendant filed what was captioned a motion to traverse. It was verified by the defendant's attorney and contained some allegations about which the attorney did not have firsthand knowledge. The court in that case said that in order to traverse, you have to file an affidavit, and the affidavit has to be filed by a person in actual knowledge, and the affidavit has to state specific facts that place the bases for attachment at issue. And if you fail to meet those requirements of the rule, you fail to traverse, you don't put in issue the causes for attachment, and the court is not required to hold a hearing. In Old Republic, the trial court declined to hold a hearing, and the Court of Appeals affirmed that decision based on the finding that the defendant had not complied with the affidavit requirement. Very similar facts here. No affidavit was attached to the second request for traverse, nor did it incorporate any prior affidavit. It made a lot of arguments relating to the weight to be given to the evidence that had been admitted at the traverse hearing, but it did not state any new evidence was available that placed those causes of attachment at issue.
Mr. Van Arsdale, excuse me. If hypothetically we conclude that incorporation of the affidavit is adequate, what about the Jane case and the procedural requirements for a hearing?
Well, so what Jane says is that all of the requirements in 102 and CRCP 102 are mandatory, though the only requirements specifically at issue in Jane were in Jane, no notice had been given, and the sheriff failed to file its return. And based on the lack of notice alone, the court said that it was a due process issue, but then it also had some expansive language that all the requirements of 102 are mandatory. And I agree with that. Every requirement of 102 is mandatory, and every requirement was met here. I agree that incorporating affidavits is sufficient for the rule. There's no reason to attach a document that's contained within the court file when you can refer to it elsewhere in the court file. But nowhere in the second motion for traverse is there any incorporation of an earlier affidavit, nor is there any reference to additional evidence. Nothing about that motion places the causes for attachment at issue. The motion entirely argues facts that were already adduced at the traverse hearing. As such, the court did not just rule that it wasn't in the interest of judicial economy to refrain from holding a second hearing. The trial court's order found that the defendants had failed to traverse, and that was a correct ruling under Rule 102. Since the defendants failed to comply with Rule 102N1, they did not traverse or place the causes of attachment at issue, and therefore they were not entitled to a second hearing.
Go ahead. No, go ahead, Judge Furman.
So what's the effect, as I asked Mr. Willman, of the second renewed writ on this appeal?
No challenge to the second renewed writ on its face or to
You agree there was no traverse?
I agree there was no traverse of the second renewed writ. I did not, in my answer brief, if this is where you're going, argue that they had failed to preserve this issue for appeal. I believe the court has discretion in that situation to still find that the issue is not properly preserved or not. I don't believe the second renewed writ is directly implicated in this appeal, and I do think that all of the same issues that are applicable to the procedural requirements for for the second writ, for the renewed writ, and for the alias writ would be equally applicable to the second renewed writ, had they been challenged. Regarding those renewed writs, the attachment rule, CRCP 102A, says that a claimant may at any time after filing a claim but before the entry of judgment, in the manner and on the grounds prescribed in the rule, move for a writ of attachment. It does not say that no second writs of attachment may issue. It does not say that a writ of attachment is one and done. It does not say that facts that were relied on in support of an initial writ of attachment may never be used in support of any subsequent writs of attachment. Language is very broad and clear. At any time before the entry of judgment, a party may move for a writ of attachment in the manner and on the grounds prescribed in this rule. It then requires a sheriff to file an inventory within 21 days. And so what is a claimant to do where the sheriff, for reasons completely outside the claimant's control, has failed to file its inventory within 21 days, but there's still significant property that needs to be attached, or else it is very likely to be removed from the reach of judgment? The answer is in Rule 102. At any time before the entry of judgment, a party may seek to have non-exempt property attached in the manner and on the grounds prescribed in the rule. That is exactly what we did here. In the manner and on the grounds prescribed in Rule 102, we applied for writ of attachment to attach non-exempt property of the defendants after the initial 21-day period for the sheriffs to attach property had expired. Because that action complied in entirety with all the procedural requirements of 102, it was proper, and it remained proper 21 days later in support of the renewed writ and the second renewed writ. The alias writ is even more clear-cut. CRCP 102F says alias writs may issue at any time to sheriffs of different counties, the very last sentence of that rule. Reading the rule in harmony to permit one to apply for an alias writ on the same grounds as an earlier writ were issued, but not apply for renewed writs, would lead to absurd results. In one county, at present, you can go get a writ of attachment to attach unattached property, but if property moves from one county to another in which you've already attached property, all of a sudden there's no opportunity to conduct an attachment. You've already attached property in that county. Now you have to wait for new grounds for attachment before you can apply for a writ. That would lend itself to the exact sort of mischief trying to remove property from the reach of judgment that Rule 102 is designed to avoid. It's also worth noting that there is no sanction in Rule 102 for a defendant working as hard as they can to remove property from the reach of attachment as soon as they become aware of the writ. Rule 102, in fact, as I read it, doesn't impose any affirmative obligations on the defendant. The writ commands the sheriff to attach property, and so contempt isn't even an available remedy where defendant is working their hardest during the 21 days that the sheriff has to attach property to keep property hidden from the sheriff. If renewed writs and subsequent writs could not issue, that would create a game of cat and mouse that would frustrate the plain, speedy, inexpensive delivery of justice under CRCP 1. Turning to my second point, no provision of Rule 102 contemplates a trial court entering findings of fact regarding the value of the plaintiff's claim. Rule 102 contains several procedural safeguards to protect defendants against having an undue portion of their property attached. It gives the trial court discretion to impose a bond up to double the amount claimed. In this case, the possible bond amount would be $6.9 million or more if the trial court wanted to find out how much the attorney's fees had accrued up to as of any given date, or court costs, which have been quite substantial. If a plaintiff were going to wrongfully claim a value in the interest of attaching more property than they would ultimately be able to recover from, and they face the prospect of having to have that amount of money tied up through the entire pendency of the case, that provides a significant deterrent to overstating the amount claimed. Similarly, the rule gives the sheriff the ability to manage the release of any attached property by requiring security equal to the value of that specific attached property, a remedy the defendants have elected not to avail themselves of here in this case. Every bit of the rule regarding the value claimed refers to the amount sworn to. Subsection B requires the plaintiff's affidavit to set forth the nature and the amount of claim for damages. Sub D caps the bond amount at double the amount claimed. Subsection F says the writ shall state the amount of the plaintiff's claim in conformity with the affidavit, which every writ here did. Every writ of attachment issued in this case stated that the value of the claim was $1.15 million plus attorney's fees and costs with statutory treble damages under the civil theft statute. By setting forth the amount claimed in the writ's complied with that portion of the rule. Subsections U and V give the sheriff discretion to fix a sum not less than the value of the property attached for surety to secure its release. In sum, the rule addresses in multiple places the amount claimed, but nowhere does the rule state that the trial court shall enter factual findings regarding the amount of the claim. And the reason for that is because that would shortcut the trial on the merits. That's what happens at trial. At trial, the finder of fact makes specific findings regarding the value of the plaintiff's claim. Shortcutting that and making the plaintiff prove its claim under a 7-day time crunch at the beginning of a case where no discovery has been conducted would deprive a plaintiff of due process. It's inconsistent with the language of the rule and the clear intent of the rule, and therefore no provision of Rule 102 requires the trial court to enter findings of fact regarding the specific value of the plaintiff's claim. Turning to my third point, the sheriff's failure to file an inventory within 21 days does not give rise to any right for a defendant to recover its attorney's fees from a plaintiff. The only fee-shifting provision under Rule 102 is subsection N2, which says that if a plaintiff fails to prevail at the traverse hearing, then that gives rise to a right for fee shifting. In Heiner v. Johnson, the court specifically addressed what happens where a traverse hearing is held and how calling something a traverse hearing doesn't necessarily mean it hails under subsection N. Where you have challenges to a writ of attachment under other subsections of the rule that do not show that no cause for attachment was present, then those are facial challenges. They can be appropriate grounds for dissolving a writ, but they do not give rise to fee shifting under subsection N1. Here, that's exactly what happened. The writ was dissolved because the sheriff failed to file its return within 21 days. The trial court, therefore, under Jane, dissolved the writ, but the plaintiff did prevail at the traverse hearing. The trial court ultimately found that the plaintiff had proved a reasonable probability that multiple causes for attachment exist, and therefore entered specific findings sustaining a writ of attachment and attaching the defendant's property. Based on those findings, it is necessary to keep the attachment in place, otherwise the property is at significant risk of being removed from the reach of judgment. That's what the attachment rule was designed to prevent, and since at every step of the way the trial court acted within the boundaries of the rule and the plaintiff complied with the rule, this court should affirm. Thank you.
Counsel, you have 4 minutes and 25 seconds.
Thank you, appreciate it. I want to mention one thing that I failed to talk about when you asked me the question about the second renewed writ, and that is the fact that one of the positions I made in addition to the jurisdiction, which I think is fundamental, is the fact they did not submit a new affidavit. And I think the contemplation of Rule 102 is every time you get a writ, and I agree, you go back and get writ after writ if you want to, you got to comply with the terms of that. And that doesn't mean you can go back and say, well, this happened in July, and therefore it's still true in September. I think you have to say there's still basis to show that there's been a concealment of assets. That's number one. Number two is Mr. Van Arsdale said that in the second verse, we didn't incorporate by reference, but I went back and looked while he was talking. If you read paragraph 16 of the second motion to traverse, I incorporated both the affidavits and the testimony, just as he had done when he asked for the second writ. I incorporated the affidavits of Ms. Kelly and the realtor, so his name just has escaped my brain. So that was incorporated. So if he could do it, obviously he says, okay, I did do that, so he's wrong in his interpretation. The third, as far as the amount is concerned, if you read the Chaffin versus Wayland case, which the plaintiff actually cited, the purpose of what they said allowing these old acts to come in, the embezzlement, was to establish the amount of debt. Thereby the court in dicta, not in law, black letter law, was recognizing there has to be an amount of debt set forth, and we think the Chaffin case does that. Next, I'd like to note that the 2-day hearing that was held, or hearing held over 2 days, I don't know if it's a full 2-day hearing, that all that showed, and I don't want to lose the forest for the trees, and that all that showed is that they had concealed a trailer which belonged to the plaintiff. This is their best case. One horse, and that actually been told, the location that had been told to the sheriff's deputy by the sons of my clients, or some of the defendants in the case, and and there were some other missing vehicles that weren't at the site. There was no showing they were being concealed. They just weren't at the site when they happened to come back. This is a farming operation, and it was farming equipment that could be anywhere, and they're real minor pieces of equipment. So the idea they were concealing this, the rule requires there be a material concealment or concealing material assets to do that. None of that was being done. Everything was being done above board. Real property was being done in a normal sale. They weren't selling the real property at a fire sale, and whether the 1031 exchange would have given them money or would have transferred, the reality is there was no intent that could be inferred from just the fact they listed the property that they were doing that. Also, the plaintiff admitted in their answer brief that the defendants knew from summer of 2016 that they were going to be charged with criminal actions. All there were calls made by my office and by Ms. Kelly's office in the spring of the following year. It was because so much time had passed, we were trying to find out that stuff was still going on. It wasn't to give them opportunity to begin selling assets. So the bottom line is that even if you say everything else for the plaintiff in the initial pleadings, which are then incorporated, the second traverse, so to speak, that are incorporated in the other writs of attachment or request for writ of attachment, there is not a material concealment of assets. The fact they may or may not have embezzled, and for the moment you have to presume those lights in favor of the plaintiff, they embezzled those assets. They're all funds of the defendant, of the plaintiff. They're not funds or property of the defendants. There was no significant material assets being concealed. There was no evidence of that. And I know the trial court has a lot of discretion, but this is clearly an abuse of discretion.
Mr. Mulliman, let me ask.
Yes.
If we were to hypothetically agree with you that some of the writs should be dissolved, but the last one that's unchallenged is not dissolved, what happens to the property? What's the effect of all of that?
I think you'd have to remand to the court to try to, if you agree with my view, it has to be an amount of damages for that determination, and then the determination of anything in excess of that would have to be released to my clients. I think that would be the effect of that if you feel the court did have jurisdiction to do that, or there wasn't a need for a separate affidavit. Was
specific property attached for each specific writ? Is that identified? All I saw was a running spreadsheet.
There was property attached after each writ that was new, yes.
So you all could track which property was attached under which writ?
There were sheriff returns that are in the file. I don't know that I can specifically tell you that.
Okay, thank you.
And I know that I'm a little over time, but as far as the attorney's fees and the prevailing party, just ask you to look at the two cases I cited in my reply brief. They both talk about prevailing party, and that really controls that issue. With that, I have nothing else. Thank you so much.
Thank you. Thank you to both counsel. The case will stand submitted, and an opinion will issue in due course. We thank you both for your helpful arguments. And we'll just sit here and wait, I think, until the parties can switch out at the table, and then we'll proceed with the next case. Thank you. Proceed.
Yes, Your Honor.
Just a reminder to anybody that is new to the courtroom, if you have any electronic devices, please turn them off or in airplane mode so that they don't interfere with our live streaming. And just a reminder, in this case, it does involve a juvenile and a sex assault, so please be mindful not to use the juvenile's name. You may proceed.
Thank you, Your Honor. May it please the court, counsel. My name is Doyle Baker. I am a deputy district attorney in Colorado Springs, the 4th Judicial District. I represent the people in this appeal. My bar registration is 22277. There's no language in section 18.3.405 subsection 2A that requires that force be used in an assault to overcome a child's will. And to answer the question that this court sent to the parties last week, the people are aware of no legal authority that would support a conclusion that a child may consent to the use of force during a sexual assault. Nevertheless, the district court in this case concluded, and the defendant contends here today, that a lack of consent requirement must be read in to that force aggravator, and that if a victim or a child has consented to the application of force, that the aggravator cannot apply. This conclusion fails simply because a lack of consent from a child victim is not an element that must be proven to establish the statutory aggravator. Neither the plain language of subsection 2A nor the statute defining sexual contact include any requirement that force be applied to overcome a child's will. And in fact, the version of subsection 2A that has been in effect since 1995 has eliminated any language that would suggest that. And as we noted in our reply brief, there used to be, under this statute, a requirement that force be applied, among other things, to get the child to submit, and that was removed. And what we're left with is the language that we have, which is very broad and does not address or even contemplate, apparently, a question about whether a child has consented. Although a child can consent, as a matter of fact, legally, it's simply insignificant whether they've consented or not. Consent to force in the context of sexual assault does not diminish the defendant's culpability. It doesn't immunize him from the consequences of his conduct. And to the extent that the district court concluded otherwise in this case, we believe that was error under the plain language of the statute. I basically laid out our position for you, Your Honors. I have nothing to add unless you have questions. Otherwise, I'll sit down and reserve the remainder of my time.
Counsel, I just have one question. Was the constitutional challenge made on appeal addressed at all in the district court?
The vagueness challenge that
Yes.
the defendant raised in his brief, I don't believe it was, Your Honor.
Thank you.
Thank you.
Good afternoon. My name is Megan Morris, bar number 43963, and I represent Mr. Hodge. The parties concede that CL agreed to all of the physical contact at issue here, and so the only question in this case is whether that agreed upon contact is force, as that term is used in section 18.3.405.2a. This court asked us to address what legal authority supports finding that the force aggravator does not apply to agreed upon contact. And the short answer to that is the plain language and the structure of the statute. I think there is some, it's important to distinguish. The district attorney was just talking about There's no language in the statute suggesting that it requires, the force aggravator requires overcoming the child's will. And I agree with that. It doesn't require causing submission to the sexual contact. But there's a distinction between that and an agreement to other contact that's related to the sexual contact. And that's what's at issue here, is whether the child can agree to that ancillary contact. I want to go through the plain language of the statute and the structure of it, but before I do that, I want to take a step back and talk about the unintended consequences of adopting the state's reading of the force aggravator, which I take to be that it applies anytime there's a force, or anytime there's a restraint, whether agreed upon or not. And not to be crude, but I think it's important to talk about how that might apply. So a couple examples, if we apply Keene, which says that a person's body weight is physical force, then I think that that means, reading that in line with the state's definition or reading of the force aggravator, that any time a sexual assault on a child occurs where the defendant is on top of and their body weight is on top of the alleged victim, that would automatically trigger the application of the force aggravator.
But didn't Keene talk about the distinction where the victim wasn't able to get away? I mean, it was the defendant's body weight that held the victim down, as distinguished from one of the victims where the defendant was on top and held her down, but she was able to get away. So it seems like it was force that facilitated the sexual assault.
That's correct. So what the court distinguishes, and I believe the district attorney pointed this out in the reply brief, that in both cases the court concludes that the body weight is force. It simply concludes that in the second circumstance for DM, that the force was not sufficient to cause submission. And so I think, again, here, so if we conclude that that body weight is force and that force includes, under the state's reading, any restraint, whether agreed upon or not, then that body weight here constitutes force for these purposes. I would also, just to give another example, if there's any kind of, arms around the other person, that would be a restraint. And again, whether agreed upon or not, that would be a restraint and would trigger the application of the force aggravator. And so my concern here is that the state's reading of the force aggravator collapses the distinction between sexual assault on a child and that same offense with force. Judge Ferry, you recognize the constitutional argument in the answer brief, and that argument is not that the statute itself is unconstitutional, but rather that this court should look to the doctrine of constitutional avoidance in reading the statute. The Clark v. Martinez case that I cited in my answer brief talks about the fact that canon is not attempting to vindicate constitutional rights, rather it's the defendant seeking to vindicate his own statutory rights, and that's what I'm asking this court to do here. The district attorney talked about the fact that the legislature eliminated the cause submission requirement in 1995. But again, they did not eliminate the requirement that the force itself must be antagonistic or against the will of the alleged victim.
Counsel, but as I read the statutory language, it just says against the victim, not against the victim's will. Is it your position that those two are synonymous in the force aggravator?
It is, based on the plain language and the context there. So just to go to the plain language, when we look at the use of the term, it's not just force, but force against. And the definitions of force, one of which the district attorney cited themselves, is violence, compulsion, or constraint exerted upon or against a person or thing. I think this word alone indicates a lack of consent, but I think that's doubly so when we have that coupled with the word against, which is defined as in opposition or hostility to. And so I think that reinforces the idea that this force must be some sort of contact that's occurring against the alleged victim's will.
But doesn't the sexual assault on a child statute, which doesn't have against the victim's will as an element, unlike the adult statute, which does. So consent is never a defense in a child sex assault. Doesn't the statute just implicitly include coercion because consent isn't a defense? Isn't that part of the sexual assault on a child?
So what I would say is that I think we all agree that there's this crime of sexual assault on a child to which consent is irrelevant, and it's an indeterminate sentencing offense. And the court found probable cause for that offense. That's not at issue here. But what we're talking about is an aggravator, that the legislature made a judgment that in certain circumstances, that offense is worse. And what makes that offense worse is that there's some sort of physical contact that occurs that is against the victim's will. And I think that's reinforced by the inclusion of the aggravators after 2A, which 2A is the aggravator at issue here, but subsequent to that we have 2B and 2C, which talk about threatening imminent death, serious bodily injury, extreme pain, or kidnapping to accomplish the sexual contact, or threatening retaliation in the future by causing death or serious bodily injury, extreme pain, or kidnapping. So I think that reinforces the conclusion that what the legislature is getting at here is an even more coercive circumstance than a basic sexual assault on the child.
Counsel, don't you think a sexual assault when the child victim is handcuffed and gagged, isn't that a more coercive sex assault than without the restraints that were used here?
So I think that the legislature could choose to aggravate in those circumstances. I simply think it has not done so here. And again, I would say that I think there's a real line drawing problem if we're just relying on the language that we have and we interpret the language that we have to incorporate restraints regardless of willingness. Again, I think that really collapses the distinction between sexual assault on a child and that same offense with force. Even though the circumstances we have here are not necessarily as common, I think the state's reading of that aggravator would actually apply to the vast majority of sexual assault on a child cases. I would also point this court to the fact that the legislature has explicitly defined and referred to some of the activities here, including sadomasochism, in 18CA1680 the sexual exploitation of a child statute, and did not incorporate that definition in this statute. It also referred to sadism and masochism in the definitions for obscenity in 18CA0710. So the legislature knew how to incorporate these definitions, and it chose not to do so in this particular circumstance. And for that reason, I think this court cannot read those definitions into the force aggravator here. Instead, based on the plain language of that statute, I think that this is something where the legislature is aggravating a sexual assault on the child based on contact that's occurring against the alleged victim's will. If this court has no further questions, I would ask this court to affirm the district court's ruling based on the plain language of the statute.
Thank you, counsel.
I think that we both agree on a definition of force as it's used in common discussion, common parlance. We both quoted from Merriam-Webster in our briefs that, and it was quoted by defense counsel in her argument that force is violence, compulsion, or constraint exercised against a person or a thing. And there's nothing in there about consent and whether that somehow changes what force is. And with regard to the unintended consequences of ruling as the people are urging you to rule, as I understand it, the concern is that there's some level of force inherent in any sexual contact, and that this court won't be able to draw the line with regard to where that should occur. And I think that Keene is helpful in that regard. There was a question there about how the force was used, and there was a big question in Keene about whether restraint could be force. And when the Court of Appeals in that case decided that force applied to the body could be used in a situation where there's restraint, and that they don't require an extra application of force other than force applied by the body. And then the court went on to say, we note the physical force or physical violence as defined here has to be used for a specific purpose. It has to be used to cause the victim to submit to, in that case, sexual intrusion or penetration. And I think that's the distinction. Force that's inherent in an act of sexual contact is not the kind of force that we're talking about under this sentence enhancer, or aggravator rather, force aggravator. For those reasons, and for the reasons we stated previously, we would ask that the district court's order reducing the severity level of our counts be reversed and that the case be remanded with instructions to reinstate the original counts. Thank you.
Thank you to both counsel for your helpful arguments. The case will stand submitted and an opinion will issue in due course. We appreciate your arguments and the time that you put into preparing for them. We'll just, do you need a recess? All right, we'll just remain here while the parties switch out for the next argument. All right, our last case is People versus Martinez Mares. Counsel, you may proceed when ready. Thank you.
Good afternoon, may it please the court. My name is Matthew Fredrickson, registration number 47453, and I represent Mr. Martinez Mares, who is present here today, the appellant. Your Honor, Mr. Martinez Mares sufficiently alleged justifiable excuse or excusable neglect for the delay in filing his secondary post-conviction petition. He also sufficiently alleged ineffective assistance of post-conviction and plea counsel. Mr. Martinez Mares is entitled to a hearing on both issues. Now, the first issue, that exception, the justifiable excuse, excusable neglect exception, requires the finding or the weighing of 6 different factors. And in Mr. Martinez Mares' case specifically, we can break that period down into 3 different sections. The first, right after the 18-month had elapsed, and after he had entered that plea before hiring Marinoff and Associates. While he was represented by Marinoff and Associates, the alleged ineffective primary post-conviction counsel, and after that representation had ended with the mandate in January 2013 and the filing of the current secondary post-conviction petition. That's the terminology I've been using to designate the 2 different kinds of petitions that we're dealing with here. This court, based on the questions that issued last week, is primarily concerned with that, or appears to be concerned mostly with that 3rd section after the issuing of the mandate in January 2013 and the filing of the secondary post-conviction petition. So I do want to start with those questions. The first question was whether or not the district court made findings about that period specifically. And my answer to that would be in the negative. The court did find generally a lack of alleged unavoidable hindrance and the passage of time and the effect on the prosecution generally on their ability to respond to the challenges. But that wasn't specific to that time period. Those were general statements. Every other consideration of the Redeemer factors did not deal with that period. So I would answer that in the negative. As for this court's ability to jump in and weigh those factors themselves, or by this court's self, I would point this court to Redeemer and its interpretation in Mershon, the other Supreme Court, or a Supreme Court case dealing with Redeemer, that it's truly the trial court that's supposed to deal with these instances in the first instance, or these issues in the first instance, so that it can weigh the facts, because these are factual determinations. And in this case specifically, and this kind of ties to that second question, what Mr. Martinez Mares alleged for justifying that period is heavily fact-based. The allegations that Mr. Martinez Mares makes for that period are seen there in pages 20 through 24 of the original petition, where he's saying that during that period, not only was he pursuing other avenues of relief, one of the Redeemer factors, But the post-conviction litigation, the primary post-conviction litigation, acted as an unavoidable hindrance because the attorneys he was pursuing was seeing that petition already in place, and that affected their ability or choice to take the case. Now, I'm not alleging that those facts appear in this record. That's the allegation Mr. Martinez-Morez makes, and that's why this is a factual determination so that a trial court can hear that testimony from those attorneys and make that determination about whether or not that embroils or affects two of the Redeemer factors, that unavoidable hindrance and the pursuing other avenues of relief. So yes, Mr. Martinez-Morez did allege factors that take into account the Redeemer factors for that time period between the mandate issuing and between the filing of the secondary post-conviction petition, which are fact issues that this court cannot dispose of just with reference to an issue or a matter of law, which we see in the Mershon case where the Supreme Court is saying, yes, as a matter of law, what Mr. Mershon alleged, that fails under the exception because he's saying there was no present need to attack the conviction that later gave rise to the habitual charges in that case because the very promulgation of the statute gave him that present need. And that is a bright line rule. That is a matter of law that cannot be a successful claim of the exception. But here, this is a very rich fact-based allegation, so this court cannot step in and be the court of first instance to deal with that. Under Close, specifically CLOSE, that Close from 2008, I know there are a number of different Closes here. That's the 180 P3rd 1015 citation. It's in that case that we see that this court reviews de novo the allegations and takes them as true. Because of the standard of review this court is applying. And so taking those allegations that Mr. Martinez-Morez offered for those 3 periods, yes, a hearing was warranted in this case. Before turning to the third question that this court asked, I want to jump just briefly to the other 2 periods in time that I kind of broke that delay or that period of delay into. We dealt with the mandate to the filing of the secondary post-conviction petition. Now I'll jump to that period during which Mr. Marinoff or the Marinoff and Associates represented Mr. Martinez-Morez. And during that period, I turned to the other close case, CLOUSE, a case from 2002, which talks about the fact that the analysis that this court is to engage in begins from the premise that he can't raise ineffective assistance of counsel against primary post-conviction counsel until that representation is over. So that period is much simpler in that there's actual case law supporting the premise that the analysis really can't take that period into account because he is already being represented by that primary post-conviction counsel whose ineffectiveness Mr. Martinez-Morez is alleging in the secondary post-conviction petition. As for the third period, that first period after the 18 months elapsed up and until Mr. Martinez-Morez hired Marinoff and Associates, the allegation there that he raised in this secondary post-conviction petition is in addition to not having a reason to question the infirmity of his prior conviction because of the affirmative misadvice from his plea counsel, he also was dealing with the intersection between criminal law and the immigration system where he was actively pursuing what he thought was his relief, checking the visa bulletin, trying to adjust his status, and that is a waiting game for people who are in that system, trying to wait for their number to come up, as it were, trying to wait for their visa availability to come up. And so he was pursuing that, what he thought was the relief he was entitled to or could get, specifically through that immigration system. And we know that the immigration system is itself a complex system, and Mr. Martinez-Morez is operating without counsel, but doing what he thinks he's supposed to be doing. And that's another avenue of relief, another variable that Redeemer asks the court to consider.
Mr. Frederickson,
Yes.
excuse me. What do we do with the prior division opinion in this court dealing with that first period?
That
The
first
first
period.
post-conviction?
Of course, Your Honor. So in that case, we have a division of this court affirming the summary denial of the earlier petition for the time bar issue. And the allegation here is the way in, because under Silva, this case cannot be successive to that case because the allegation starts with the ineffectiveness of post-conviction or primary post-conviction counsel. And primary post-conviction counsel was ineffective in how they alleged the justifiable excusable neglect in the earlier case. They only raised in front of that court that Mr. Martinez-Morez had no reason to question the allegation. It did not deal with the other elements or factors of Redeemer. It didn't even argue Redeemer in the first petition until the reply. And so the allegation here is that primary post-conviction counsel was ineffective in how they initially alleged or dealt with the exception in that primary post-conviction petition. So this is something of a leapfrogging back, that we have to address the primary post-conviction counsel's ineffectiveness in dealing with the Redeemer and the justifiable excusable neglect issue. Now, what that court had in front of it, and what a lot of divisions that this court deal with, is just allegations that are raised for the exception in the lower court. A good example of this is Mershon, because in Mershon recognizes a number of different bases that were alleged for the justifiable excusable neglect, but because only one survived on appeal, that's the only one that Mershon dealt with. And that's why Mershon could dispose of the issue as a matter of law. And that's so vital, is what the primary post-conviction counsel is alleging is the justifiable excusable neglect, because that's all that really survives to the Court of Appeals and what the Court of Appeals is acknowledging. And we have that in this opinion from Judge Terry, where she is only looking at the unavoidable hindrance and the prejudice to the state for the depletion of the records. She's not dealing with the other issues, she's just looking at what was dealt with below. And what was dealt with below is a product of what primary post-conviction counsel necessarily presented to the lower court. And because the allegation here is that primary post-conviction counsel did not sufficiently allege the Redeemer factors, that's all the district court had in front of it, and that's all that the division of this court had in front of it when it went in front of a division of this court. You'll see that Judge Terry does not deal with all of the issues in Redeemer, and that's because not all of them were dealt with below and could have been raised. And that's a lifeblood of the secondary post-conviction petition, is that the merit of the ineffective assistance of primary post-conviction counsel is a failure to fully and meaningfully allege the exception to the time bar. And that brings me to the third question asked by this court, whether or not, if time bar is not an issue, is there merit to Mr. Martinez-Morez's claims? And I would answer that in the affirmative, because he was given misadvice by his plea counsel of his plea's immigration consequences. Plea counsel did not do that necessary investigation to properly advise him, which is ineffective assistance of counsel under both Pozo, this state's opinion of Pozo, and our Supreme Court's opinion in Padilla. We also have the ineffectiveness of primary post-conviction counsel for the myriad of things alleged in Mr. Martinez-Morez's secondary post-conviction counsel, in addition to failing to properly argue Strickland and properly argue Redeemer and the justifiable excusable neglect exception. Also a number of attendant issues there with his representation, or their representation of Mr. Martinez-Morez. And then if this court is worried, just to kind of circle back to your question, Judge Dunn, about kind of any successiveness concern, or the fact that the other court has dealt with the issue, how do we deal with that? I would stress that what an allegation of ineffective assistance of primary post-conviction counsel is doing is it is saying that primary post-conviction counsel failed to reveal the initial infirmity in the original proceedings. That's what secondary post-conviction counsel is trying to reveal, is how primary post-conviction counsel failed to reveal the infirmity in what happened to the defendant, who's at the heart of all of this, suffered in that initial proceeding. And because primary post-conviction counsel neglected valuable or available litigation, that is how this court can reach back to before a division of this court dealt with that, is because primary post-conviction counsel was ineffective in how it dealt with Mr. Martinez-Morez's issues. And we can use as a backdrop People v. Martinez-Huerta and People v. Chavez-Torres and People v. Alvarado-Hinojos, other opinions from this court, divisions of this court, that have dealt with something very similar to what Mr. Martinez-Morez is alleging here, and found differently. So effective counsel would have come to a different result. Of course, Marinoff and Associates could not benefit from those opinions, but it's an interesting backdrop to see how experts could come in and testify that primary post-conviction counsel, even the attorneys involved in those cases, could come into the trial court and testify to how Marinoff and Associates was ineffective and how they argued and alleged the exception to fail to bring about the hearing that all of those other defendants benefited from. And so that's really what this court would be doing, is saying they failed to bring about the proper outcome of that primary post-conviction petition, which is a hearing on justifiable excuse, excusable neglect. Experts could come in to testify to how that is. The attorneys in Martinez Huerta, Chavez Torres could come in and testify to how that is, but that would be a factual determination for that determination of justifiable excuse, excusable neglect, and the merits of the claim against primary post-conviction counsel as we leapfrog back to getting Mr. Martinez-Morez's allegations actually heard on the ineffective assistance of plea counsel that he received. So with that, if there are no further questions, I would ask that this court remand for a hearing on justifiable excuse, excusable neglect, as well as a finding of ineffective assistance of primary post-conviction counsel for their failure to elicit the relief that Mr. Martinez-Morez was entitled to. And I'll reserve the remainder of time for rebuttal.
Thank you.
Good afternoon, Your Honors. My name is Joseph Michaels, attorney registration number 40403. I'm here today on behalf of the people of the state of Colorado. I'd like to start, I think, by addressing this court's questions, but before I do, there are two primary reasons to affirm the district court's, in this case the post-conviction court's, denial. And the first is that the defendant simply has not alleged with specificity any justifiable excuse or excusable neglect for that 3.5-year period between when the mandate issued in the prior appeal and when he finally filed a second post-conviction motion alleging ineffective assistance of counsel in that case. The allegations that he does allege are sort of general, don't give specific timeframes of when that ineffective assistance prevented him from pursuing the second post-conviction claim. And in that respect is first refuted by the record as on its face, and second refuted as a matter of law based on decisions from divisions of this court. The second reason that this court can simply deny the defendant's appeal in this case is that the allegation of ineffective assistance of first post-conviction counsel fails on its face as a matter of law, and that sort of leads me into this court's first two questions. Now, the first question, just to refresh everyone's recollection, my own particularly, is that the district court didn't make any findings concerning justifiable excuse or excusable neglect between that 3.5-ish year period. And the answer is mostly no. And I agree with opposing counsel on that point. There's no specific subsection where the judge went aside and said, now let me address this period from the mandate. But the judge on page 12 of the order does very specifically address this idea of there appears to have been, quote, confusion over the prior proceedings, and then the defendant fails to allege any unavoidable hindrance that caused him to neglect to file his second 35C. And it's sort of a confusingly worded statement, but that phrase, the confusion over prior proceedings, clearly references the first post-conviction challenge and the first appeal, and sort of the facts underlying that. The trial court ultimately addresses justifiable excuse from the time of the initial plea back in 1998 and finds that the entire expanse of time isn't subject to justifiable excuse, which is exactly what the first division that considered this question considered, with Judge Terry writing. Now, this court knows the defendant has the burden of establishing justifiable excuse and excusable neglect. And there's no allegation, especially with that 3.5-year period after the mandate, that the defendant simply didn't know about the timeliness requirement. And the defendant doesn't allege how long within that 18 months afterwards was attributable to either not knowing or not having counsel. And those are the two real legal claims that I was able to sort of take from that 35C, the second 35C allegation. One, that the defendant simply didn't know that the mandate had issued, and two, that the defendant was searching for counsel. But this court's decisions in People versus Merchant, it's written merchant, but I can't imagine that's how it's pronounced, and People versus Vigil, both of which are cited in my briefs, talk about the lack of legal counsel is not an excuse to the time bar. And I'll just read those cites to you so you have them right here. The first one is Merchant 983 P. 2nd 108, pin site 104. And Vigil is 955 P. 2nd 589, pin site 591. And Vigil particularly says, ignorance of the law or lack of legal assistance does not constitute justifiable excuse. So the fact that the defendant was not represented during that time, as a matter of law, that fails. And that goes to a sub-question in that first question this court asks, which is, can this court resolve it without a factual determination? And I agree with opposing counsel that anything that involves a factual determination has to be by the post-conviction court. But as a matter of law then, under close, the 180p 3rd 1015 close, matters of law can be determined by this court in the first instance. And as a matter of law, not having an attorney or seeking to have an attorney represent him is insufficient as a matter of law to establish justifiable excuse.
Mr. Michaels, isn't the allegation here a little more nuanced, that because of post-conviction counsel's ineffective assistance and the resulting order, he was unable to obtain counsel that he was actively seeking? I mean, it's a little bit different than just not having counsel.
I take your point, Your Honor, but the fact remains that he still could have then filed something on his own. It's not about having counsel. And Merchant, Vigil, and numerous unpublished decisions from this court have repeatedly said that in order to satisfy the time bar, the defendant can file on his own and then find counsel later or supplement with counsel later. So that's something that could have happened within that first 18-month period, irrespective of whether or not the first post-conviction counsel muddied the water, so to speak.
Mr. Michaels, do we know that for sure, though? Because he alleged that post-conviction counsel and appellate counsel didn't communicate with him, and that he didn't know when the opinion issued. So does the record establish that he actually knew the outcome of the appeal within the 18 months of the mandate?
I have two responses to that, Your Honor, if I may. The first one is that his statement that he is actively shopping for attorneys throughout that time period demonstrates that at some point he knew. And in fact, there's even a statement, I'm trying to recall at this point if it was in the original 35, or the second 35C filed in this case, or whether it was in one of the appellate briefs. But they concede that he knew of it by mid to late 2014, so within 18-ish months of the January 2013 mandate date. And the second response that I have to that is there is statements from the first post-conviction counsel and first appellate counsel saying, we communicated him. We told him when we were denied in the trial court. He paid us. Granted, the payment does not appear to have been complete, but he paid us to appeal, and so we relayed that outcome to him. And that is on, if you can bear with me for a moment. It's in the second post-conviction in the record, the court file, pages 104 to 105. It talks about that idea of the defendant requested the file late in 2014, so he knew he was seeking a representation by mid to late 2014, and he knew that there's a statement on page 105, paragraph 30, that first post-conviction counsel informed the defendant promptly. So in that respect, yes, this court can make its own findings, and yes, under Vondra and Arness, this court can affirm on grounds other than what the post-conviction court found. Similarly, and I think we've sort of addressed a little bit of this, the second question asks, what specific facts of justifiable excuse or excusable neglect for the time period between those 3 years? And the two facts are largely that I didn't know that my appeal was ended, but we have record refutation of those facts, and I was searching for attorneys, which, as we know, is rejected as a matter of law. we know he was attorney shopping. We know attorneys did not want to take the case because of the prior appeal, which demonstrates definitively that the defendant, in fact, was able to relay to those attorneys that I had previously appealed. Ignorance of that time bar just simply does not establish justifiable excuse or excusable neglect. And I would urge this court to remember that this isn't a global rejection or acceptance of the defense claims. This court is narrowly focused on whether he alleged facts for justifiable excuse or excusable neglect for a hearing down below. It's not a broad search for whether there was justifiable excuse or excusable neglect. It's whether he was entitled to a hearing on that matter below. It's not about whether first post-conviction counsel was ineffective as a matter of law, or whether he established the claims at the root of it that first post-conviction counsel was to address. And I would note that in that 3.5-year time span, we don't have an allegation of specificity. We have a general allegation of the defendant didn't know that my appeal had been completed, or I was searching for attorneys. But he doesn't say at what point he starts searching for attorneys. He doesn't say at what point he learned or didn't learn about his appeal. And that is his responsibility under well-established principles of justifiable excuse, excusable neglect, and 35C context. Turning to the third question, I don't believe that the merits do establish that he's entitled to relief, but I would caution this court that the merits aren't about concerning the immigration plea. The merits are concerning whether first post-conviction counsel was ineffective as a matter of law. Those are the merits that are at issue in this case. The question then is whether the first post-conviction counsel and first appellate counsel was ineffective as a matter of law, and I would submit no. And the reason I submit no is because the very issue that he is raising here is that first post-conviction counsel failed to argue convincingly justifiable excuse or excusable neglect. But that argument, the entire crux of that argument is not that he failed, Mr. Marinoff or Mr. Baca failed to argue justifiable excuse or excusable neglect. It's that he would have done it differently. Put another way, that's a matter of strategy, not a matter of ineffective assistance or failing to identify an issue. And I would note that the prior division of this court specifically addressed that issue. The prior post-conviction court specifically addressed that issue and said this just doesn't establish justifiable excuse or excusable neglect. The wrench in the gears comes later, after this particular appeal has been resolved and another division of this court has decided Martinez-Huerta, which says this does establish justifiable excuse or excusable neglect. This kind of claim does establish that. But it's the exact same argument that the prior division, Judge Terry, rejected that was later accepted. That's not something that establishes post-conviction counsel as being ineffective, constitutionally ineffective. It just says that this court and that the Martinez-Huerta division disagreed with this prior division. And on page 27, footnote 10 in my brief, I cite a number of cases that similarly decided that such claims do not establish justifiable excuse or excusable neglect. Martinez-Huerta just changed that. And that question is now before the Colorado Supreme Court in the two cases that opposing counsel cited, Chavez-Torres and Alvarado-Hinojos.
Counsel, I found kind of glaring in post-conviction counsel's 35C motion the failure to even cite to or argue the Wiedemer factors and the failure to cite to or argue Strickland. Those seem to be two pretty big cases in ineffective assistance of counsel law that post-conviction counsel should have had in the motion. Can you address that?
I can, Your Honor. The first I would respond is that while those particular cases are not addressed, it's clearly addressing this idea of justifiable excuse or excusable neglect. And in fact, the district court, the post-conviction court, specifically analyzed under that. And perhaps more importantly is that Mr. Baca's Mr. Baca's brief to this court in the prior case specifically addressed Wiedemer. And it's on pages 11 and 12 of that brief. Let's see here. It looks like it's exhibit in the court file, pages 42 to 47, is the Court of Appeals opinion, and then in the exhibits PDF, it's pages 26 to 37. There's a separate heading, there's a separate argument saying justifiable excuse or excusable neglect. There's a separate argument that specifically says Wiedemer. And on pages 11 and 12, it addresses each one, it recites each one of those Wiedemer factors. So that issue could not have been more squarely presented to the division of this court for review. And it's the exact same argument that was made in Martinez-Huerta. Martinez-Huerta just went the other direction. So in essence, Martinez-Huerta disagreed with that prior division's decision in this case, but that's not a function of failing to argue the Wiedemer factors. It's a function of Martinez-Huerta simply coming to a different conclusion. In essence, then, what we're talking about is a challenge to how the council presented those issues to the post-conviction court, which is not a deficiency in performance. It's simply a disagreement with how it was presented. And so in that respect, I would say that this is the exact same argument that ultimately prevailed in Martinez-Huerta. So simply having a different division come out a different way doesn't mean that this division, this attorney, was ineffective for failing to present it. And so I suppose maybe the best way of thinking about it is, while Wiedemer might not have been mentioned or delved into deeply in the opening, it was in the response, is my recollection, and the claim was directly addressed, recognized, and considered by the court, even if the method of arguing and the method of post-conviction counsel, the method of appellate counsel arguing it, differed in sort of emphasizing instead the specific facts of the case. I would also note that at the point of that 3-year span between the mandate and this case, the defendant knew about that time bar limitation, because that's exactly what had been resolved against him. And he didn't even at any point below request the withdrawal of the plea. He simply said, I would have wanted to have known. With that, my time has past expired, so I ask that you affirm the post-conviction court's order. Thank you.
Thank you. Can you please add 14 seconds to the rebuttal time?
Thank you, Your Honor. Yes, very quickly, I would point the court to Exhibit J attached to the secondary post-conviction petition, which adds some corroborating evidence to support that Mr. Martinez-Morez was searching for attorneys to help him during that third period. I think that adds or responds to some of what the Attorney General has said. I would also encourage this court to go back and read Vigil, People v. Vigil, because it's the lifeblood of this ignorance of the law, not having an attorney, bright line rule promulgated by a division of this court way back in the early 90s. And I don't think, based on kind of a very heavy reading that my firm has done on it, I don't think it really gave rise to this bright line rule that a lot of future courts are looking at it for, because what it did was credited the lower court for doing a fact finding, because in Vigil it went to a hearing on justifiable excuse, excusable neglect. The court just said we don't see an unavoidable hindrance in the record cited to Roe, but Roe was excused or disapproved of by Wiedemer because of Roe being based on faults. And that's kind of explored better in my reply brief. But we cite to Vigil, all of these cases cite to Vigil, but I don't think Vigil says what all of these future courts are saying it says, because Vigil is really based on Roe, and Roe has been disproved of.
Mr. Fredrickson, I want to go back to something that counsel said, and that's that the record refutes or establishes when your client knew that the appeal had come out, and he says that there's support that it was 2014. If that's the case, doesn't that just refute some of the post-conviction allegations?
And Your Honor, I'm seeing that my time is out. Can I answer your question?
I would appreciate it.
Yes.
Your Honor, because of that added claim of the failure to communicate, Mr. Martinez-Morez didn't even know his case was being appealed. So he did not know really what was going on with the appeal until well after that mandate had issued. But I say all of this because we're blurring the line slightly between what I know as his counsel and what would be presented at a factual hearing.
So you're just saying there's some factual dispute on when he knew? Okay.
Yes, and that's why we would have a hearing. Thank you, Your Honor. And with that, I would ask that this court remand for a hearing. Thank you.
Thank you. Thank you to both counsel for your helpful arguments. We appreciate the time that you put into preparing, and we will find it very helpful. The matter is considered now under advisement, and we will issue an opinion in due course. Thank you both. That concludes our docket for today, and the bailiff may announce a recess.